So the ICO is the UK regulator for the Data Protection Act, the Freedom of Information Act, the Environmental Information Regulations, and the Privacy and Electronic Communication Regulations, so very longly worded pieces of legislation. We will be the UK regulator for the General Data Protection Regulation as of May 2018 as well. Elizabeth Denham is the current UK Information Commissioner, and she took up the role in July 2016. Many of the ICO staff and operations actually come from our head office in Wilmslow in Cheshire, where we've actually currently got over 400 staff. But in addition to our head office, we've also got 3 offices in Belfast, Edinburgh and Cardiff, which were set up in 2003 as a response to devolution. The ICO's office in Wales, so based in Cardiff, currently has 6 staff, including me. We're headed up by our regional manager, David Teague, and we've also got a senior policy officer, the lead policy officer, which is myself, a support officer on the general information rights side of things, but we've also got 2 dedicated FOI case officers in the Wales office who investigate FOI and EIR complaints against Welsh public authorities. So we're obviously here today to talk about the General Data Protection Regulation, but I think it's really useful to firstly take a look at the current law which is in place, which is the Data Protection Act 1998. The DPA has actually been enforced in the UK since 1998, so 19 years ago, and that creates obligations for you as organisations who process personal information. So before we go on, let's look at a couple of key definitions that the Data Protection Act refers to. So when we refer to data controllers throughout this presentation, we basically mean organisations, so those of you that are in control of the personal data that you collect. And on the other hand, when we refer to data subjects, we basically mean the subject of the information, so the individual who the data is about. Now, for all of you, that could be service users, it could be members of the public that make inquiries to your offices, and it can also be staff, so you as staff as well are data subjects in respect of some of the information that your organisation holds. The DPA is based on 8 principles of good information handling practice. These are really common sense principles which all individuals would expect organisations to abide by when processing personal data. These range from things such as ensuring personal data is processed fairly and lawfully, to making sure it's not held any longer than necessary, and also to ensuring that the data is processed fairly and lawfully, ensuring that the data is afforded the appropriate level of security as well. So pretty common sense principles that when you give your data to organisations, so your bank, the NHS, etc., you'd expect those 8 principles to be complied with. If you think back to the types of technology you were using in 1998 when the Act was first introduced, I think it's fair to say that the way our personal information is used has changed hugely. So smartphones are now part of our everyday lives. We can download apps that require our personal data before we can download them, and many of us wear devices such as fitness devices that use our information in ways that really wouldn't have been imaginable 19 years ago when the Act was introduced. So whilst many of the main concepts and principles of the GDPR are very much the same as those in the existing Data Protection Act, GDPR really brings that welcomed 21st century approach to data protection. So, as I said, many of the main principles and concepts of GDPR are the same as DPA. So if you're in a position where your organisation is complying properly with the current law and you're in a really nice position, then most of your approach to compliance with GDPR will remain valid. Put simply, those organisations joining us that are doing things well under the current law will find that there's much less of a step to navigate when May 25th, 2018 comes around. However, because there are some new elements that GDPR introduces, all charities joining us today will find that there are some things that you might have to do for the first time perhaps, and other areas where you will have to start doing things slightly differently. So because of these changes and enhancements, it is essential that you plan your approach to GDPR and get the relevant buy-in now from the key people ahead of May next year. So what are the key changes? Firstly, one of the kind of main changes is GDPR will really help individuals feel more in control of their data. This is because of the increased rights that they'll enjoy under the regulation. So these include increased rights for data to be deleted, data to be rectified, and also being able to access copies of their information free of charge. There'll also be much higher penalties if things do go wrong with personal data. Many of you will have heard that if organisations do get things wrong, they can potentially face a monetary penalty of up to 20 million euros or 4% of annual worldwide turnover. When things do go wrong, organisations will need to report certain breaches of the GDPR to the ICO within 72 hours, and also to individuals if that breach is likely to result in a high risk to the data subjects as well. So that's not under the current law, but under GDPR there is that timescale in order to report things to the regulator. Some of you might find that you'll also be legally required to appoint a data protection officer, but we'll be covering this in more detail later in one of the later steps. So, referring to steps, today's webinar will be looking at the 12 steps that we've been recommending organisations take in order to prepare effectively for GDPR. This guidance has been out for over a year now, so some of you may have already seen it, you might be quite familiar with it, but it's actually been revised this week, so it was revised yesterday, which marked the year to go date for GDPR, so 25th of May 2018, so actually at this stage we're under a year to go. So if you haven't had sight of the slightly revised 12 steps guidance, then head to our website at the end of this webinar to have a look. So now that we've looked at the background and the history of data protection in recent years, and we've also looked at some of the key definitions, let's now have a closer look at those 12 steps that we're advising you take now, while we're just under that year date until the implementation. Awareness is the first step, and it's a really key step. If you can think that with less than a year to go, planning your approach to GDPR at this stage is absolutely essential. Part of this planning process really does ensure that you gain the key buy-in from the key people within your organisation, by making sure that those that are really kind of responsible for decisions in your organisation are aware of GDPR. They're more likely to appreciate the impact that the change in law is likely to have. And for some of you smaller organisations, it might be quite a big impact that it's likely to have. So definitely, really worth getting that buy-in at this stage now while we've got time. We've got a really extensive range of charities and voluntary organisations listening today. So some of you, just off the top of my head, the county voluntary councils, you'll have a great reach, and you'll also be able to influence not only those within your organisation, but also those that you have dealings with. So raising awareness with members and partners, not just within. So there's the awareness on two strands, so internally, but also externally. The second step is to take a look at what you hold at the moment. Now, I know this might sound silly, but taking stock of the information you hold ahead of GDPR will allow you to identify an appropriate legal basis for the information that you're holding currently. GDPR significantly emphasises the rights of individuals, so knowing what you hold and also where you hold it means that individuals will be much more able to exercise their new rights and enhanced rights under the GDPR. So just an example to kind of paint that picture. If you hold inaccurate personal data and a data subject lets you know that it's inaccurate and you need to rectify it, you'll also be required under GDPR to inform third parties if you've disclosed that inaccurate data to any third party. So if you don't know what you hold and you don't know who you've disclosed it to, then it'll be really tricky to meet your obligations under GDPR if you do get a request for rectification. Now, the third step is looking at the kind of privacy information that you give individuals. So one of the new rights that GDPR creates for individuals is called the right to be informed. This right to be informed is usually done through what we call a privacy notice, and that's basically information that you give to individuals at the point of collection in order to explain to them how their information will be used. This is really important for those such as housing associations, and I think we've got a couple listening today, who sometimes might share information with third parties, as data sharing might not always fall within someone's reasonable expectations when they first hand you their data. So not just housing associations, but anyone that's involved in any data sharing with external, third-party organisations, your obligations to give people in information is relating to that sharing is really key at that initial stage in order to meet the right to be informed. GDPR also requires you to tell individuals more than what's required by the current law. So, for example, you'll have to tell individuals what lawful basis you're actually relying on. You'll have to give them a bit of information about your data retention periods and also about the fact that they've got a right to complain to the ICO if they're unhappy about the way that you're handling their data. GDPR also requires you to give this privacy information in a clear, concise and easy to understand way. So I'm sure that you'll all agree, like me, that it's a really welcome change to those badly worded legalese privacy notices that I'm sure we've all seen at some point, when you can't make head nor tail as to what the organisation is going to do with your data. For information, we've recently updated our privacy notices code of practice, and that includes the additional requirements under GDPR. And our overview of the GDPR document, which is on our website, also has a really useful table that details the categories of information that you need to give individuals, when you're collecting their data. So it's really worth having a look if you haven't already done so. Step 4 relates to individuals' rights. So I've already explained that GDPR really does strengthen the rights that individuals have in relation to their data. The full list of rights can be found in our overview document that I've referred to. So it's important at this stage to check your procedures to ensure that all of your systems and every other procedure covers all of the rights that individuals might be able to exercise in relation to your organisation. Helping people to understand their rights in relation to the data that they have, it really does empower them and it helps them feel in control of their data. Now, if you're listening today from somewhere such as advocacy support or citizens advice, you're in a really good position to help individuals that use your service understand the rights that they have, because a lot of people aren't aware of rights that they have under the existing law, so the same could be said for GDPR. So I'm sure that you and others will be really interested in these changes, and you'll be able to share that knowledge with the service users that you have regular contact with. So on the whole, the rights of individuals under GDPR are much the same as those that we've got under the DPA, but there are some significant enhancements. For example, the right to data portability is new. Now, this is a right for someone to obtain and reuse their data across a number of services. So it only applies in some circumstances, so it might not apply to everyone listening today. It basically applies if the data subject has given you the information themselves, if you're relying on the basis of a consent or a contract, and you're also processing that data by completely automated means, then you should really consider whether you need to revise any of your existing procedures in order to make any changes. If you can identify any areas of your charity where this might apply, then you will need to provide the data in a commonly used machine-readable format and also provide that information free of charge. So again, really worthwhile having a look at your systems now, seeing if there are any areas where that right might apply, because you'll be in a really good position then to, a year to go, you'll be able to fully prepare to make sure that you can handle those rights to data portability requests that you might receive. The next right that we're going to discuss, or the next step that we're urging organisations to take, is relating to subject access requests. So the right for people to obtain copies of their data from you organisations that are holding it, it's strengthened under GDPR. Now, it's strengthened because the standard £10 subject access fee is actually removed under GDPR. And also there's a shorter timescale for compliance. So it will actually be 1 calendar month under the new law in which you'll need to respond to a subject access request. If your organisation handles a large number of subject access requests, it's really important that you consider the logistical implications of having to deal with those requests more quickly, because it's around 10 less days that you'd have under the new law than you would under the Data Protection Act. That would be particularly important if your organisation deals with quite complex issues. So I know I've mentioned citizens advice already today, but you'll really benefit in looking at the kind of implications that will have, because you record issues that relate to quite a wide range of topics. So issues relating to debt, employment, benefits, housing and health. So the requests that you deal with, they might be less straightforward than a smaller organisation that might be holding slightly less information. So it's really important to prepare for that kind of increased subject access right. The next step is to look at the lawful basis on which you're relying in order to process personal data. When we spoke earlier about privacy notices, one of the additional bits of information that you'll need to provide through that privacy notice is to include the legal basis on which you're relying on in order to process that data. Many organisations listening today will be aware of what legal basis you're relying on for the different types of data that you use and collect and process, but some might not be under the current law. For that reason, it's extremely important to identify your legal basis ahead of GDPR, because some of the individual's rights might be modified depending on the legal basis that you're relying on. So an example of that would be people will have a stronger right for their data to be deleted if you're currently relying on their consent in order to process that data. This really does reinforce the need to carry out that information audit that we referred to under step 2, so that you can ensure that you've got a valid basis and a good legal basis under GDPR for all of the information that your organisation is processing. So it really did link to that second step of taking stock of the information that you hold. The next step, and this is another legal basis for processing, this is one of the options that you might be relying on, it's consent. Now, many of you might have seen our recent consultation document on our consent guidance. The final version will be out in June, hopefully. But GDPR raises a standard that you'll need to meet if you are relying on consent for any of your processing. This applies to every organisation, whether you're a local charity that's quite small or one with a national presence. So what does GDPR raise in terms of that kind of gold standard of consent? Under GDPR, consent would need to be granular. So by granular, we mean that if you're collecting information for different bits of processing, where possible, you would need to make that clear. So for example, if you're collecting data for marketing purposes, you're collecting it perhaps for fax marketing, email and telephone marketing, you would be able to, or you would have to give the individual the option to consent to each of those different processing options. So it would need to be granular. You can't just ask someone to, do you consent to being marketed for all of these three things? It would have to be on a granular basis. Consent will also need to be unambiguous. So what we mean by that is that there can be no more than one way of interpreting what you're going to do with that data once you've got their consent. So it's got to have a very clear meaning. And finally, or not finally, sorry, but one of the other strands to consent, you'll need to have a clear opt-in mechanism. So it needs to be an affirmative, positive action. So that means that those of you relying on pre-ticked boxes at the moment, or consent by silence or perhaps inactivity, those approaches will not be valid under GDPR. We've published detailed guidance on the topic, we will be in June when the revised document comes out. That'll be including a checklist for those relying on consent, so a nice little kind of quick-to guide if you are relying on consent. So at this stage, you should really review the areas of your organisation where you do rely on consent, and look at things such as how do you seek that consent, how do you then record and manage it on an ongoing basis. And if your existing mechanisms under DPA don't meet this new GDPR standard, so if it's not unambiguous, it's not granular, you've got a pre-ticked box so no one is able to take that positive opt-in action, then you will need to refresh those consents to make sure that they're compliant under the law. The next step that we're looking for is, that we're looking at and asking you to prepare for, is in relation to children. So for the first time, GDPR will bring in special protection for children's personal information. So for that reason, I'm really pleased that we've got organisations on board today, such as Play Wales and Valleys Kids, because this step will be really important to your organisations and indeed other organisations that are also capturing children's personal data. So firstly, when you do collect personal information directly from children, GDPR requires you to communicate that privacy information notice that we've been talking about in recent steps in a language and a manner that children will really understand. So not only have you got your obligation to put that information across in a clear and concise way for any individual, regardless of age, if you're then targeting services at children and collecting their information, you also need to make sure that it's child-friendly as well. So not using big words that a child might not understand. Secondly, if your organisation offers what we call an information society service, which is basically online services to children, and you rely on the consent to collect that information, you may need to put in place a system to verify the age of the individuals and also put mechanisms in place to obtain parental or guardian consent for that processing. This is because GDPR requires parental consent for children under the age of 16 when their data is being processed for the purpose of an information society service. So again, that definition is quite a narrow one. It's a service that's provided at a distance, often for remuneration. There's scope for the UK government to lower this age to a minimum of the age of 13, so it can't go any lower than that. But again, this will be for the UK government to decide, so it's not a decision that the ICO will be taking. And for those of you that are a bit unclear about this aspect, then our overview of the GDPR document really does contain useful information on this. So that's children, so definitely have a look at where you're collecting information relating to children. So step number 9 relates to good old data breaches. Another area of significant change under GDPR is this area, so this area of when things go wrong and the law is breached. First of all, what is a data breach? Now, the GDPR defines it as a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorised disclosure of or access to personal data. So nice long definition as we can see. Data breaches are therefore much wider than data simply ending up in the wrong hands, which I think a lot of people just assume, data breach, I've sent it to the wrong person, I've left it on a train. It is much more than that. So this more expansive definition really does require you as organisations to have confidence that all of your staff are able to detect a data breach, given that quite wide definition. This is especially important because, as we mentioned previously, GDPR will require all organisations to report certain types of data breaches to the ICO within 72 hours. Where a breach is likely to result in a high risk to the rights and freedoms of individuals, it will also need to be notified directly to those concerns if that threshold is met. So it is really important, therefore, that your organisation has procedures in place that effectively detect, report and investigate personal data breaches. Failure to report a breach when it is required to do so to the ICO could potentially result in a fine, as well as a fine for the breach itself. So I'm sure, for everyone's benefit, it's really important that you do get those kind of procedures in place to effectively detect data breaches within your organisation. And I think it's key to remember that that applies to all staff regardless of level. So whether it's someone that's got minimal access to personal data, that might often, they might occasionally open letters or send emails, to someone that's handling really sensitive data on a daily basis. Because we've got so many charities listening today, I think at this point, while we're talking about breaches, it's worth highlighting the recent enforcement action that we took against a number of charities. And that action was in relation to poor practices when fundraising. So although fundraising is going to be the topic for the next desktop data webinar in June, it's a really useful point to highlight the fact that organisations don't just breach the law by losing data. It can happen when you do things such as share information or collect and use information such as profiling without people's knowledge. So again, GDPR doesn't stop things such as data sharing or profiling individuals, but it really does set really kind of high protection measures in place if you are going to do that. So again, data breaches aren't just losing data, it can be a lot more than that, especially for those of you that are fundraisers as well. The 10th step that we're urging organisations to take is kind of assessing a data protection by design approach. Now, it's always been really good practice to think about privacy matters ahead of new projects, new initiatives involving personal data, but GDPR makes privacy by design an express legal requirement. So it makes what we call privacy impact assessments mandatory in certain circumstances. GDPR refers to those as data protection impact assessments. But for those of you that have never heard of PIA or DPIA, it's basically a way of, before using a personal data for a new project or initiative, having a look at data protection up front rather than having to go back at the end of a project and realising, we didn't think about data protection, this project wouldn't be lawful under GDPR or data protection currently, so we actually can't continue with it. So having that privacy by design approach is really, it's key, not just for the rights of individuals, but also for you as organisations in terms of saving time. If you get to the end of an initiative and you think, well, actually, we can't roll this out because it doesn't comply with the data protection law, then you've lost a lot of time and resources. So PIAs are really important. And as I said, they'll be mandatory under GDPR in certain circumstances. So those are, first of all, if a new technology is being deployed. Second of all, where a new profiling operation is likely to significantly affect individuals and where there's processing on a large scale of special category data. So for information, special category data is more or less what the current law defines as sensitive personal data. So it can be things such as relating to health, political union affiliation, trade union membership. So yeah, it's very much similar to what the current law defines sensitive data as. And for information as well, the ICO has already got really useful guidance on conducting privacy impact assessments. So it's really key that you start to familiarise yourself with the concept of a PIA. Well, we've got a year to go until GDPR. The 11th step that we're urging you to take is relating to data protection officers. So some of you listening today might be joining us from larger organisations. You might have a head office in Cardiff or London or elsewhere in the UK. So the scale of your organisations might mean that you've already got a dedicated data protection officer who's then responsible for making sure that the law's complied with. It might even be you listening in today as a DPO. So given that we have got a lot of smaller organisations, it's likely that the majority here today might not have a dedicated data protection officer. So while these roles aren't mandatory under the current law, GDPR requires DPOs to be formally designated in some circumstances, and these are as follows. First of all, if you're a public authority. Second of all, if you're an organisation that carries out the regular and systematic monitoring of individuals on a large scale. And thirdly, if you're an organisation that carries out large-scale processing of what we just referred to special category data. So that can be information like health records or information on things such as criminal convictions. So again, have a look at your processes in place, see whether any of those 3 strands would apply to you, and you'll be in a really good position then to determine whether you would be legally required to have a formal DPO appointed. The role of the DPO is basically to inform and advise their organisation and employees as well about how to comply with the GDPR, and then to monitor its ongoing compliance as well. They'll also need to be the first point of contact for the supervisory authority. So in this case, in the UK, it would be the ICO. So definitely have a think about whether you would be required to get one in place by May next year. And step number 12 relates to international kind of dealings. So firstly, there's kind of 2 strands to this one. The first one is if your organisation operates in more than one EU member state, you will need to identify who the lead supervisory authority will be. So when we say that, we basically mean the regulator that's going to be your point of contact relating to GDPR. So for those of you that have EU-wide organisations and your main establishment is in the UK, then the ICO will be the lead supervisory authority. So we would be the one that you would come to for your compliance with GDPR across, regardless of the fact that you're kind of based in more than one EU member state. Now, I don't know how many of you that will apply to. So this second strand is the one that's likely to apply to almost, if not all of you. So the second strand is basically for those who share information outside of the European Union. I've been informed today that organisations such as Keep Wales Tidy and Chwarae Teg might have European partners, but this could also potentially apply to you if your organisation doesn't have any kind of European dealings, but you use cloud computing services. So, as I said, that might kind of hit off all of you in that case. So GDPR doesn't stop you from being able to process information outside of the European Union, but it does require you to ensure that when you do send information outside of the EU, the level of protection that your data subjects will be afforded in that destination country is not undermined because you're sending it to that particular place. Personal data may therefore only be transferred outside of the European Union when at least one of the conditions of transfers under GDPR is met. Now, I appreciate that this sounds quite techy over a 1-hour webinar, but more information can be found on our website. There's a lot of information on there and in our overview to GDPR document. So those are the 12 steps. I'm aware that I might have whizzed through them, but given it's lunchtime, I'm sure many of you might be desperate to get off. In terms of the guidance that we've got now, so what do you do now as an organisation? Obviously, start complying with those 12 steps if you haven't already done so. We've got a really useful section of our website, which is on the screen there, so ico.org.uk/dpreform. That's the kind of hotbed of where we're going to put all of our guidance relating to GDPR. And that includes the document that I frequently refer to, so the overview of the General Data Protection Regulation, so this nice blue and yellow document you can see on the left. And on the right, this is a smaller document, but this is the one that this presentation has been based on today. So although you might not have grasped everything today, because I might have been going through it at super lightning speed, please have a look at that document if you hadn't already done so. And that's the one that was actually updated yesterday, because it's just under a year to go, which this slide nicely kind of captures. Yesterday, in order to celebrate the 1 year to go mark, we introduced a really nice revised toolkit for small to medium enterprises. So although you're all from the voluntary sector, given your size and the scale of your processing, I think the toolkit that's on our website as of yesterday might be really useful for you all to have a look at. So it basically breaks down a couple of the areas that you need to look at into manageable bite-sized chunks. So the toolkit consists of questions that focus on areas such as information security, records management, data sharing, and direct marketing, but that's just 4 of a few. So please do have a look on our website for the updated toolkit. And what that does, it asks you a series of questions that kind of marks you on a red, amber, or green status, and it will suggest further reading. If it feels that there's a couple of gaps that you need to work on as an organisation, definitely head to our website, and because it will kind of suggest the further reading that you'll need to do in order to help prepare fully for GDPR. So I certainly hope that you've enjoyed that kind of quick tour of the 12 steps that we're urging you to take now. I think it's really important to mention as well that the ICO's office in Wales, so WCVA are obviously here to help as well. Our office in Cardiff and our national office as well, we're here to help. We do understand that GDPR is quite a daunting time for many, especially if you're from a smaller organisation. I will reiterate the point that if you're getting things right under the current law, you'll be in a really good position as of 25th of May next year. It's going to be much less of a kind of step to navigate, as I said before. Please do feel free to contact us. So my telephone number's on the screen. You've got our email address as well. We're on Twitter, LinkedIn, YouTube. We've got really good training resources on YouTube, I should mention. But yeah, please certainly get in touch if we can help with anything. But thank you for all listening.
Thank you, Bethan. Okay, now so over to you. Does anybody have a question that they'd like to ask Bethan? If so, if you can start typing them in, please, that would be great. And just to remind you as well that the dates and the topics of the next desktop data webinars are 26th of June, fundraising and data protection, 25th of July, cyber security, 22nd of August, privacy notices, September, we're looking at safeguarding and data protection. And also this is your opportunity now that if there are any topics that you'd like the ICO to go into any detail on, we can perhaps think about sort of scheduling them in for future webinars. So feel free to add those to the chat pane as well. So thank you, Lucy. We have our first question. So how does this impact on cloud storage?
So the impact that GDPR has on cloud storage is not much different to the current impact it would have under the current law. So those 8 data protection principles I referred to earlier, the 8th one is that information shouldn't be transferred outside of the European Union, or sorry, the European Economic Area without adequate protection. So at the moment, if your organisation is using cloud storage, then it's important to check where those cloud servers are based. If it's within the EU, then you'd be complying with Principle 8. If it's not in the EU, then DPA or GDPR wouldn't stop you from carrying on using that cloud server, but you would just need to make sure that you've got the appropriate safeguards in place. So under the current law, we've got a really good guidance document on our website. I think it's, if you type in cloud computing on the search bar of ico.org.uk, it should come up as the first result. But basically, if you're kind of aware of what cloud servers you're using at the moment and you're aware of where they're based, then as long as you're happy that you're complying with the current law, have a little look in our overview guidance to see how it slightly changes in relation to international transfers. But yeah, so the impact would be GDPR would apply, but it's just important to know where those cloud servers are based. So thank you for that question. I hope that answers it.
Brilliant. Okay, so we've got another question on its way from Catherine. And just to say as well, the ICO have an excellent live chat function on their website. Yeah. You don't really have to type in your details. It can be anonymous, and if you have a question, you can always just type it in to the live chat pane. Yeah. Which is an alternative way of speaking to the ICO.
Definitely, it's a good point, Emma.
So we're just waiting for this one from Catherine. Does anybody else have any questions that they'd like to ask at this moment?
I told them everything.
Okay, we'll just wait for this one then. No pressure, Catherine.
But definitely have a look at ico.org.uk as well, because it's there's charity pages, so information relating directly to charities. SME section as well, which really does help, grasp data protection and how to comply for those smaller organisations amongst us. So if you haven't already done so, ico.org.uk is a really useful tool.
And I suppose another point I just wanted to add as well is that the ICO are in the process of creating guidance documents for GDPR as well.
Yeah, and those that kind of ico.org.uk/DP reform section, if you save that as one of your favourites and you go in every few days, when we do add new guidance, it is really evident on that page what's new and what we've released that month, etc.
Okay, brilliant. So we have a few questions. Have you got any ideas on how to word the acquiring of granular consent?
In terms of acquiring that granular consent, the focus would be on whether you're writing it in a way that's unambiguous. So how you set it out, you can be quite creative with, but as long as it's clear that that individual is consenting to different processing. So as an individual, if I was signing up for marketing with your organisation, you're asking for my consent, it would need to be quite clear, if you are going to email market me, if you're also going to market me by fax, or so that granularity would link in very much to the way that you're wording what you're going to do with my data. So if I know you're going to market me in terms of, I don't know, if I sign up to a theatre's mailing list and you say, we'll let you know whenever there's a new show in town. But then if I start getting marketing that's completely not within my expectations, that I was never told that I'd get, then that's the area where, my reasonable expectations are starting to be thinking, well, hang on, I wasn't expecting that. So it's kind of bordering then on the fairness of that processing.
Okay, thank you for that. Next question from Anne Harrod. What is a reasonable amount of time to keep a person's details?
Under the current law, so Principle 5 of the Data Protection Act states that you shouldn't keep personal data longer than necessary. Now, that's the kind of how long is a piece of string principle, but it really does put the power back in your court as the organisation. So as the data controller, what key 3 things that we would look for in order to determine how long is necessary? First of all, is there a legal requirement for you to keep that data? If there's a clear legal kind of gateway that says you need to keep this type of information for X amount, then that would be, that's quite clear. That's the amount that's necessary. In the absence of a legal stipulation about how long to keep things for, have you got any kind of sector guidelines? So you as a sector, is there anything that's agreed amongst your industry, any sector approved codes of conduct, etc., that do set out how long you should keep information for? Then you would look to those. And in the absence of any kind of legal requirement or agreed industry standard, we would be basically looking for what's your business need to keep this information. Now, many organisations but some organisations out there might be keeping things just in case. So, that they're too scared to get rid of it just in case. Under the Data Protection Act, that's really likely to breach some of those principles, because if you keep it then indefinitely, and me as an individual giving you my information, I wasn't aware that would be kept for 30 plus years. I thought it would just be used for however long you need it. Then that's when you're likely to be bordering on a potential breach of Principle 5 of the current law, and then also the kind of related article in the GDPR as well. So that's a good question, but it really does give you the power to think how long is necessary for my business needs.
Great, okay. I'm looking at some of the other questions. So from Catherine, will GDPR have an impact on the current guidelines when holding photographs?
So photographs, that's a good question, Catherine, thank you. Photographs still apply if it identifies a living individual. You've got all your similar considerations that you would need to take in terms of the current law as well. So the fairness side of things, so does an individual know that you're taking photos? Depending on what legal basis you're relying on, so if you're relying on consent to take photos and then display them, bear in mind that GDPR has a really strong right in relation to consent. So if I give you my consent to process my data, at any time I should be allowed to revoke that consent, because consent under GDPR needs to be freely given. So if you've asked for my consent for the photograph and I then revoke that, GDPR means that I'm in a stronger position to say, well, I don't want you to hold that photograph anymore. So it's going to be very similar to the current Data Protection Act, because the principles still very much apply to photos. So I hope that answers it, Catherine.
Okay, and a question from Kerry. Will there be standard privacy impact assessments, or will organisations have to create their own?
There's not a standard kind of a set one, but our Privacy Impact Assessments Code of Practice under the ICO's website, on the ICO's website, has got really good annexes in terms of detailing the types of information you would be looking for. Organisations can be creative in terms of how they set out that information. It's basically key that the information contained in that Privacy Impact Assessments Code is in a PIA. How you then display it would, it would be...
We'll wrap this up then. Thank you very much, everybody, for joining our webinar. As you can see, the next sessions planned are available in the chat page.